to Calcutta after a very long time. Before I start, I must convey my good wishes and health to everybody participating here, and do hope that each of you, your family and your loved ones are healthy, safe, as we transition through this most extraordinary journey. Why I call it transition? Because I'm a firm believer that we shall pass this soon. Today's topic is the legal implication on COVID-19. Whilst I am the one who's speaking now, I must mention that there are some of my other partners who've helped prepare and will be taking on questions. There's a large Calcutta team which is there, which is headed by the 4 partners from Calcutta already there, headed by Shurjo Ganguly. There is Shurjo and Pooja Chakravarti are in disputes. Nidhi, who will be in real estate and probably help in questions on HERA, and Orko, who will also help in questions on labor. And the presentation itself was prepared and held by Aditi Chaudhary, who's an M&A corporate partner out of Bombay, Astha, the banking finance partner for the finance related questions, and Orko for the labor questions. So in terms of COVID, we've decided that probably take this in 4 key impact areas, which from a legal perspective as a lawyer, one should look at in terms of the real estate sector. We are all acutely aware that this sector, real estate, and you've been reading, is probably one of the most impacted sectors with COVID, and it's been a volley of impacts with the DeMon and the GST and now this. And I truly believe that this is a sector which the government needs to look at very, very, very closely, and needs to come up with some packages for the sector. We understand also what we read, that affordable housing space is where the focus would be from the government to help out. And hopefully there could be some concessions the government grants in this. Coming back to the 4 key impact areas which we want to cover. And after we finish that, I think that the way we planned was we finish it and then there'll be question answer sessions. I'll try to finish it in the next 40 minutes. The 4 key impact areas which we try to cover is, first, of course, the more popular one, which is the contractual obligations and the force majeure, the various contracts which a real estate developer, the real estate industry gets into. Next is an extension of that, which is really what happens. Force majeure is for contractual performance. What happens when you're unable to comply with law because of certain impediments, certain force majeure or natural impediments. After that, we will be discussing about financial obligations, how banks, funds, creditors, what will be their rights and how regulations are coming up in that. And lastly, the labor issues. These are the 4 impact areas which we should be speaking about. The first, of course, is force majeure. Now these, which I've put it on my screen, are typically the documents, the agreements which a real estate industry looks at, not in any particular chronological order. There is the agreement to purchase, maybe with the landlord, then the development agreement. You could have different forms of development agreement, and you could have the JDA or even the DMS, the joint development agreement, or which is, there is an interest which moves to developer, and a development management services, which we see nowadays a lot, where another developer comes in more as a contractor. You see construction contracts, finance documents, of course, investments agreements with private equity funds, maintenance contracts, sales of the residential and commercial units, and of course, lease of the commercial units, which comes in. And each of these documents would have the rights and obligations of the real estate developer. Just as a context, the discussion will be more from the perspective of a real estate developer. So the force majeure is broadly can be categorized in 2 routes, if I may use the word. One route is something which is already built into a contract. So you have specific clauses on force majeure, which is built into the contract. Or if you don't have it in the contract, then you rely on section 56, which is the doctrine of frustration. So either you have it in the contract, and if it is there, or it is not enough in the contract. So you may have a force majeure clause in the contract, but it may not cover certain eventualities. It could be. So just for example, we've put up a typical force majeure clause, which is there in most of the contracts, in construction contracts and development agreements, even in your sales kit, which says that standard, it could change. Neither party shall be liable to other for any loss or damages occasioned by or arising out of act of God. So basically a force majeure is an act of God. It's a French term, which gives an excuse to the party to not perform its contract. And it's built, not perform its obligation. So it's an act of God, as such as unprecedented flood, volcanic eruption, earthquake, or other convulsions of nature, and other acts such as, but not restricted to. If you see, this particular clause does not have a pandemic in its definition. However, if you look at it closely, there are two ways to look at it. Whether we can say act of God and other such acts, but not restricted to, which prevents the performance of the contract and which could not have been foreseen or avoided by a prudent person. So debate would be first, is there the pandemic which is specifically put in here? Or can we say other acts such as, and not restricted to, and have principle of adjustum generis and try to bring it and say, you know, I can't, a pandemic is not specifically put it in there. Be that as it may, the government of India, as you all know, had notified on February 19, the Ministry of Finance, that force majeure as a natural calamity. So I am not getting into what the argument could be. There are contracts, there are covenants which could be broader, and therefore you could build in the word pandemic into the definition. But suppose you don't have a force majeure contract, or suppose you don't have, or let's say it becomes difficult to bring in the word pandemic. Suppose you don't have a force majeure clause in your contract, or suppose you are unable to bring in the word pandemic into the definition, then you rely on something which is called the doctrine of frustration. The doctrine of frustration is a principle which is, for India, we are lucky because it is under section 56. So that's the next door. So the first door you see is, I'm just going back, first door you see, knock and say that does your contract give you an exit clause? The exit clause may be called force majeure or may be called anything else, that on the happening of certain events, you are not required to fulfill your obligation. And if you do not find that clause there, so one is you need not have that clause. Let's say this clause is not available, unlikely so in most construction development they are there, and sales contract, for some reason it is not there, or the words are not enough to bring within it's the pandemic, then you knock on the second door, which is the doctrine of frustration. This second door is for India, it's borrowed from UK laws, as most of our laws are. But this second door for India, there is a specific provision which is under section 56 of the Contract Act. But the basis of doctrine of frustration is an exception rather than a rule, because the rule is that a person is bound to perform its promise which he or she had promised under the contract, and the court should not interfere under any manner altogether. However, that principle has evolved because courts in England stepped in, and certain hardships which they recognize that it is impossible to carry. And this rule of absoluteness that you have to perform were eventually watered down, albeit with a lot of circumspection and a lot of framework around it. It's not a widely used provision. However, as far as India is concerned, even section 56 has had a lot of interpretation issues. Section 56 are broadly in three categories. The first says there are three provisions in section 56. An agreement to do an act is impossible. So if you enter into an agreement which says that we agree to create something out of magic, that itself is void under Indian law. Okay. Next is the doctrine of frustration clause, which says a contract to do an act, which when the contract was made or after the contract is made, that act which you promised, when you made it, it was not impossible. But after you made the contract and you got into an agreement, it became impossible or it became unlawful by reason of some event. And that therefore becomes void. So let's say person A has promised to do something. At the time of its promise, let's say I'm just giving an example, to supply X amount of crops from his field. After 3 months, there is a massive flood and could not, and it's an event which is the person couldn't have known, became impossible later. And therefore that becomes a void contract. The third part is, had the person known, in the first example, had the person known that what he is promising now, today, is possibly will make it he may not be able to, he may get hit by the impossibility or the illegality clause and therefore may not be able to perform it, then that person A ought to compensate person B. So you can't hoodwink. So you would have certain special knowledge where you would have known that a certain act which you're promising will become. So these are the three parts, but obviously the subjectivity around it is so much. Now I must mention that whilst if you look back, this is what the Contract Act says, but just the sheer number of judicial precedents which captures this and the imagination of the courts makes this particular provision one of the most unique provisions, because it changes from fact to fact to fact and circumstances. And there is no fit-all principle, and even though we are speaking about certain key principles in the next slide, there are not principles, and those principles will also need to be evaluated and tested against those fact situations. Just to give you a simple example, there is about 130, 140 years ago, there is a landmark case of Bombay and Persia Steam Navigation Company, 1890. In this Bombay Ship Company, he refused to take on the ship, their job was, the contract was to take people from the ship to Jeddah, from Bombay to Jeddah. And the ship owner was supposed to wait for people who were coming from Singapore to Bombay. This is 1890. Smallpox broke out in the ship. And smallpox was extremely, I'm just giving the context of smallpox because there is a case like that which has happened. And smallpox broke out. The ship owner said that, sorry, I cannot take you all for the ship from Bombay to Jeddah because you all were in the ship and smallpox, or you all were in contact with people who had smallpox. I cannot do that. Further, section 269 of the IPC, also the company said, I can't, because section 269 of the IPC, which is a provision which says any person who takes any action which causes the likely spread of a disease will be prosecuted and may be incarcerated as well. So the company used this before the Bombay High Court and said, listen, I cannot because there's a smallpox and it is contagious. The court did not hear the plea of frustration because it says, so what I'm trying to say is that each of these principles change from time. The difference, of course, to that time there was no lockdown, there is a lockdown today. So there is an impossibility there. We will discuss these 8 principles broadly and very quickly. The reason I'm doing that, it can be tested when you look at your contract, whether you're receiving it from your, let's say, a construction company, or when you are as a developer receiving it from a tenant, okay? You can test against these principles and find out whether at all there is a valid claim, or consequently when you yourself want to issue a force majeure notice, whether it can be. The first, of course, is that the underlying event should be so fundamental that it strikes at the root of the contract, okay? There are 2 cases, just to give you an example of that. So the first one is an English case, Henry versus Krell versus Henry, where it says that this person had hired a room to see the king's coronation. Person A, the defendant, the plaintiff had hired and said when the king's coronation in London, hired the room for about 3-4 nights, so whatever number of nights. The king's coronation was cancelled because the king was on. This is also more than 100 years old. And then he wanted refund. The English courts, though they did not have the section 56 because of common law, held that the reason the contract was entered into was clearly to see the king's coronation because that was a part of the contract. And it has gone into the root of the contract. And therefore, it will you can get shelter under the doctrine of frustration because the reason why you entered the contract, that reason has ceased to exist. On a conversely opposite case, the Supreme Court of India in Satyavrata Ghosh case, which is a landmark case, this was a case where the person had land and he was developing a township. And there were roads and canals and roads and something which had to be built there. It was during the wartime and the army had requisitioned the land. Okay. And the plaintiff wanted to claim doctrine of frustration. The Supreme Court did not allow and said that this is not. So basically what was only taken in a small part, the person knew that this was wartime and it is not that you're making it as if the wartime does not exist. And more importantly, it is a temporary requisition. So it does not kill the contract completely. So did not allow to terminate the contract. So first thing, does it hit at the root of the contract? Second is events should be unforeseen and not within the contemplation of the parties at the time of contract. Now, what happened? This is an important, this will be a lot of debate on this issue. What happens to contracts which are entered into in February or January? When, and again, it will be how you argue it depending on case to case. Let's say you entered into a contract in December. Your argument, one of the arguments is, no, sorry, there will be no doctrine of frustration applicable to you because, the news of Wuhan was already out and you all should have, a man of prudent diligence should have found out and understood. You can still argue, listen, look at the media in India, it was not still as crazy as that. But suddenly, if you have entered into a contract in February, that means you would have known that something is coming up and you did not take this into. So if a contract was entered into in February for performance of certain obligations in March, April, there could be a possibility that this would be a clause which may be triggered by the other party saying that this is unforeseen or the court. I must mention also, as I told Amit that what we speak here today is legal views, not legal opinion. For legal opinions, we will have to be far more detailed on facts. We're just trying to introduce you to some of the principles, and maybe each of you would have different facts, and hopefully these will come to help when you are evaluating your own contracts. The third is the impossibility to perform in not just a physical or a literal impossibility. This is a good one, but the language says impossible, but the courts have further toned down the language and says, hello, it's not just impossible, even impracticable. A recent case of Kenneth Builders in Delhi in 2016 or 17, where they were supposed to do a township where DDA, Delhi Development Authority, had given to them, which even DDA did not know. The EC had come, and suddenly the Ministry of Department of Forest said that one part of the project is a ridge and therefore you cannot construct there. Now the question of the township was therefore not that it's impossible to create the township, but it is impracticable to create the township there. And Supreme Court did favor the developer and say, hello, we understand it is completely frustrated because no one knew about it. It couldn't have been foreseen. And suddenly, even after EC was done, as a post facto, the government came and said, don't do it, and therefore it becomes impracticable. Next is the contract recognizes the supervening event has already allocated the risk. Now, this is a part where some of the contracts, where they have a force majeure clause, and yet, or they have certain clause which says that, like power contracts, where they say that despite it's a take or pay, whether you take it or not, or there is a minimum guaranteed amount which you have to keep on paying it despite whatever happens. Now, one of the challenges where OYO seems to be, which is, as we all know, OYO has been news, and OYO has been issuing force major notices across the world. But OYO, I don't know whether they said, one of these could be that despite if anything happening, you had promised to pay 20%. Okay. There are other provisions which can help them, or somewhere in a case where electricity was supposed to be consumed, a minimum amount has to be paid despite what you're taking. And then you can't come and say that because of this happened, I can't take, because you've already promised that despite any offtake of electricity, you still have to pay the minimum account, which means that the contract already recognizes that, something of this has already been taken place, and actually allocates the risk. There is an old case of Nayati Jute Mills, which effectively where the contract says that I was supposed to import, one of the parties was supposed to import, but the petitioner could not import because the petitioner did not get the license, the import license. And the court held that you knew very well that you had to get the license. Your contract itself has clauses which says if you don't get the license, what happens? Because of a war or whatever that a license you're not getting, you have already allocated the risk of such eventuality. And therefore, this is more in infrastructure projects maybe, or other projects where force major clause in infrastructure projects and road or projects or port projects are far more complicated, and the consequences are far more complicated. It would be more applicable there. The fifth one is, of course, a common sense one. You cannot say that it has become more onerous and burdensome, and therefore I will not be able to perform that. A lot of people have been using, again, a recent judgment of the Supreme Court, which is Energy Watchdog, and where there was a sort of a non-escalable, there was no pass-through for the power company and the price of coal. So the power company was entered into a PPA and was supposed to sell the electricity to the purchaser at a particular price. The contract did not stipulate what would happen if the coal price goes up, and there was no pass-through of coal prices to the end consumer. The court said that just because it is more Indonesian coal went up, the cost of coal went up, and the court held that, listen, sorry, your contract, just because it is onerous, okay, merely because it is onerous, cannot itself be a ground of it to invoke the doctrine of frustration. Next is, of course, the financial impossibility, which is also the OYO case, more an OYO case, where the 20% commitment which OYO has done to the owners, whether that will come in and whether they can say I cannot, will be an interesting question of law. I again said that, these are different times. You are looking at, we've been having hearings. I think one of partners who've been doing hearings on the High Court. These are different times, different situations. We don't know whether OYO will sustain this defense, but these are the principles which we've culled out on various judgments in terms of financial impossibility. I cannot pay. I mean, that obviously is a larger issue, because if everyone comes and says I cannot pay and therefore should be excused, obviously it doesn't work. The economy will go for a toss. Next is a temporary impossibility may not lead to frustration of a contract, which is also the Satyabrata Ghosh case, which is the first one where Supreme Court says that, the army has just taken for a short period of time for building your township. Your obligation for building the township cannot come to an end. You cannot terminate the contract of the entire township. It's only a small portion, and you should have known that it is on war, and it is only for a temporary period. The army will give it back to you. So unlike in a contract, and I must say the contract may, if the force major clause was in the first door in the contract could have given exit clauses, or contract could have not given exit clauses. Contract could have given long cure periods, or certain, like I said, in infrastructure projects, if this happens, then you wait out for 6 months. If it's temporary, if it still consists, that if force majeure is still sustaining, only then will it be a termination. So therefore, even the same principle is applied even in of doctrine of frustration, where if it is for a temporary period, the court will be disinclined to give and terminate and agree to a termination of a contract. And of course, which is the section itself, which says that there is no force majeure event which could have been prevented as a result of the party's own own default. So the question is that the Naihati Jute Mills case, where someone did not have the import license and was obligated to get it, just because something happened and the import license could come, if the event would have been prevented by the party itself, if it's in the contract, it wouldn't have happened. So summarizing these, as I said, this is not in any law book. These are more from our own drilling down and trying to broad. This is just to help you all to tick the box and say, hey, listen, these are the tests. I test these principles against the contract that I have, against the arrangement that we have, and see whether at all, whether we are receiving or whether we are issuing can sustain.